Thank you, Honorable Commissioners, for that introduction. Before we delve into the interview, I wish to disclose that Honorable Minda worked with me in Nakuru. So I know her in that capacity. Commissioners will be engaging you with questions on your application for the position of a judge that you have made here. But before we go into the questions, you can confirm to us your county and your ethnicity.
Thank you, Honorable Chair. My county is Kisumu.
Kisumu.
My ethnicity is Luo.
Very well. The first set of questions will be guided by Honorable Masharia.
Thank you.
Okay, thank you. I have two questions. I'm looking at your CV, which is quite comprehensive, and you've served in many areas as a chief magistrate, but more importantly also as a commissioner of this commission. So, which brings me to the question that could you tell us two things? One factor that you take into consideration if you became a judge that would make you a very impactful judge. And when I'm asking this question, you know, there are many judges that become appointed, you never hear of them until later on when they retire. Now, what is it that you think you do, just that one thing that would make you be very impactful as a judge? Then as you're answering that, what pitfall again you would avoid so that you don't become one of those judges who get there, then they run afoul, you know, with either the judicial code of conduct or the laws of the country, or, you know, they get again into trouble. So you answer from both perspectives.
Thank you very much. Thank you, Honorable Chair. Thank you, Commissioner. I don't know whether I should introduce myself or I go straight to the question.
You can maybe briefly, you can introduce yourself briefly.
Thank you.
What you've done, then you go straight to the question.
Thank you. Thank you very much. As indicated, my name is Emilio Minde Onyando. I am currently a chief magistrate serving as Kiambu Law Courts. As you can see from my CV, I graduated from the University of Nairobi with a Bachelor of Laws in 1989, with a diploma from School of Law in 1990. I did a short stint at the Office of the Attorney General, joined the judiciary 2nd May 1991, and I have diligently served uninterrupted until this moment in time. I've headed various courts, notably Makadara, Machakos, Kibera, Kikuyu. I've been deputy registrar, family division, and I've worn many hats apart from being just a magistrate sitting in court, hearing and determining cases. I have sat in this commission representing the interests of the magistrates, registrars, and caddy for 2 successive terms. I have been very active in the welfare associations within the judiciary, Kenya Magistrates and Judges, Kenya Women Judges, and even in the East African Magistrates and Judges Association, which is an affiliate. And in all those associations, I've always served as secretary. And so, of course, I've developed, developed many skills in these capacities that I've had, which I am sure will be useful to the institution: leadership, organizational, communication, team building, court and case management, and mentorship skills. So coming to the question, but I thank you also for giving me this opportunity to come and defend my application. Now, coming to the question, if we look at Article 165 on the mandate of the High Court, and we look at the constitution that we currently have, it is a very, very transformative constitution. It is a constitution that has put people at the center. The Bill of Rights is very expansive. The High Court is the first port of call in the interpretation and application of the Constitution. Now, because we have this very new, transformative, people-centered Constitution, and as a High Court judge, one of my key mandates is to interpret and apply it. The thing that I will be remembered for is that I will be a judge who will not shy away, but will interpret this Constitution in ensuring that the basic fundamental rights and freedoms of the citizenry is not only guaranteed, but it is protected to the extent that we can then say that we are a constitutional democracy hinged on the rule of law, respects the fundamental freedoms and rights of individuals, promotes good governance, just in ensuring that the rights of people are protected. I will not shy away from disciplining government when there is need to do so in matters judicial review, in matters declaring unconstitutional or invalid acts of parliament that go against the fundamentals of the Constitution. And so I would say that I would be a judge who is alive to the fact that the people have placed upon me a trust to ensure that everything that I do in their name is done to ensure that they feel that they matter within the Republic. The pitfall then would be to ensure that I would need people to trust my decisions. I would need a situation where people say, if your matter is before Minde, you need not worry yourself, because whatever it is that you're deserving of, you will get. And of course, then I will ensure that not only will I apply the Article 10, leadership and governance principles, uphold integrity and the independence of my decisions at all times in applying and interpreting the Constitution and any other law. That is how I'd want to be remembered, as a judge who was faithful to the dictates of the Constitution, even when it was not convenient to do so, even when, let me say, it was dangerous to do so. Thank you very much.
You, in answering the questions, you preempted some of the questions I'm going to ask. So I'm satisfied. All right.
Thank you.
Thank you, my lady. Once again, good afternoon.
Good afternoon, Commissioner.
So I have a quick question for you. There's a principle of res judicata. What do you understand about that principle?
Now, the principle of res judicata is a principle of law that is meant to ensure that disputes come to an end. So therefore, it applies where, if a dispute has been heard by a court of competent jurisdiction, and the same parties that would want to bring another matter appeared before this court of competent jurisdiction, they litigated over the same subject matter, then they are stopped by the principle of res judicata from again opening the same litigation before another court, so that as much as possible, disputes come to an end once a court has rendered itself on the issues before it.
Okay, that is correct. Now, let's say you are successful in your bid to become a judge, and you find yourself in the family division.
Mhm.
And an appeal has been brought before you where the respondent is complaining that, or rather the ground of appeal is that the matter that was heard in the magistrate's court, in the family court, in the magistrate's court, had been heard before. That is to say, between the respondent and the petitioner, there had been a divorce petition heard earlier, say 5 years ago, and it was dismissed. Subsequently, after 5 years, the petitioner has brought another divorce petition, and the respondent raised res judicata, but the magistrate allowed the divorce. If you're not clear about the facts, let me repeat them. Should I repeat the facts?
No, I think I'm clear.
You're clear. So what would your decision be, if that is the sole ground of appeal? What would your decision be and why? And feel free to cite any case law if you have any.
The issue on the 5 years, what happened during?
The respondent who has appealed to your court is saying, before this decision I'm appealing now, there had been a divorce petition between me and my wife, for example. And the divorce petition was dismissed 5 years ago. So they had a divorce petition before the magistrate's court. 5 years ago, it was dismissed. Now, 5 years later, the wife filed another divorce petition. And the respondent raised res judicata, but the magistrate allowed the divorce. So the respondent is before you on appeal and is saying the magistrate should not have listened to this case because it's now res judicata.
Now, if they were the same parties, they are the same couple, they are seeking divorce.
Yes.
The magistrate's court had jurisdiction, had the matter substantively, and you said dismissed or allowed?
The first time dismissed, 5 years later, another petition is brought.
Before the same magistrate?
Before a magistrate's court.
No, it ought not to have been heard. I think the principle of res judicata ought to have applied. And so therefore the other magistrate's court ought not have had the divorce petition if the parties were the same, and the grounds for divorce were the same, and the court had jurisdiction.
Yes, that's where I wanted to zero in. So this is a divorce that was had 5 years before and dismissed. 5 years later, a divorce petition has been brought. What is the consideration you would have in making a decision in that scenario?
In the High Court?
Yes, in the High Court. You're now listening to the appeal.
Commissioner, I'm not very clear on that one, I'm sorry.
Okay, maybe just by way of guidance, would the grounds still be the same grounds that were entertained 5 years ago? If the divorce is a subsequent petition is brought 5 years later?
The grounds, okay. I think you'd go by the grounds for divorce in the Marriage Act?
Yes.
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 In the petition. So the grounds may not necessarily be the same, but they could be expanded. They are more expanded under the Act.
Yes.
Yes. Whereas, if I'm not wrong, I think the grounds for divorce in the Magistrates Court Act, are set out in the Act.
Yes.
Yes, in the Magistrates Court Act. Yes.
So what would be the difference in the subsequent petition if you look at it?
Now, if I look at the Marriage Act, the difference would be, number one, did the officiating pastor have the capacity? Did the parties have capacity, mental or otherwise? Were all the parties present at did they attend to the marriage?
Those are the grounds that would make the marriage valid.
If it is not consumed, or if this marriage has not been consummated, since the marriage was entered into, then if during the subsistence of the marriage, one of the parties is mentally unstable.
Yeah, those are the issues that will invalidate the marriage, isn't it?
Yes.
So what I'm asking is, if, for example, 5 years ago I came and failed to prove cruelty, is it possible for me to come again 5 years later on the ground of cruelty? Now I've broken it down. Is it possible for me to come and say, this person, I mean, I want to divorce him on the ground of cruelty?
Mm-hmm. I don't think so. Let me just say I'm not very clear.
Oh, okay, thank you.
Thank you.
Thank you, my lady.
Thank you. When you are answering, Commissioner Macharia, you mentioned the power given by the Constitution to the High Court to interpret statutes, the constitutionality or lack of it. The courts have been criticized of late for declaring statutes unconstitutional without any basis. Are you aware of that criticism, and in which area?
I think the greatest criticism, Honorable Chair, is particularly the one on the unconstitutionality of the sentence of life imprisonment in sexual offenses. Because if a child is between 8 and 12 years and that child is defiled, then the perpetrator is to be imprisoned. It's the minimum sentence is life imprisonment. The courts have found that this is inhuman and degrading punishment because of the indefinite nature of the life sentence. And so I know of late, the Court of Appeal has set the life sentence at 30 years. I am also aware that there is a situation where the High Court reduced a life sentence to 15 years. And so there's a lot of hue and cry, particularly from organizations which deal with the rights and welfare of the child, that those sentences do not consider the circumstances of the victims. So that is one that is ongoing.
And what is your own view on that inconsistency in sentencing, especially where there are the minimum provisions in the law?
My view, Honorable Chair, would be that we need to set a definite sentence. Even if we agree that the indeterminate nature of the life sentence is such that it is inhuman, degrading and inhuman, we need to cap it at something. Because I would agree with the persons who are the hue and cry. Because particularly one, the offender was 6 years old. The Court of Appeal one, the offender was 8 years old. Now, if you sit in a court hearing and determining cases of defilements, I'm not saying that we must empathize with the victim because we are supposed to be very dispassionate, but we cannot close our eyes sometimes to the brutality that is meted out on these young people and left with scars for life. And so I think we need directions such that we have maybe not less than and not more than. But then again, I was asking myself when I was looking at it, the age of criminal liability is 12. And then we say a life sentence can only be up to 30 years. Now, if you have to sentence a child, or let's say an offender, or let's take 18 years. Now, if he was 18 when he committed the offense and you had 30 years, at 58 years, he's out. Now, in my view, it is possible that he could commit even more horrendous offenses along this line. So I'm thinking a 58-year-old, 60-year-old is still very capable, because we have had sexual offenses where the perpetrators are even 65, 70, and
I think your views are valid, because that has gone on to even probation period for the perpetrators of defilement.
Yes.
Yeah, so your concerns are also valid. So to the next segment of that question, what are the guiding principles when you have to find a statute is unconstitutional? At least 4 of them that would guide you. You explained very well when you asked.
Yes. Now, of course, the presumption is that every statute, whatever goes by the Constitution.
Yes. The presumption of constitutionality is one. Two.
Is one. Then you must ask yourself, what is the purpose for the enactment of the statutes?
Yes, the purpose, number 2.
Yes. And then what is the mischief that the statute was meant to cure? And then, of course, it must conform, everything about the purpose and the objects of this statute must conform to the provisions on the national principles of governance and the Bill of Rights. It must not then infringe on the rights and fundamental freedoms of any individual.
I'm actually happy with that. In Kiambu, what are the most prevalent challenges in your courts?
In the day-to-day administration of the court or hearing and determining cases?
Yes, the cases that bother you there.
Yes, in Kiambu, we have a lot of defilements, robberies, and obtaining by false pretenses.
It's criminal offenses that are most prevalent.
Yes. Now, one of the challenges is the documentary aspect of it when it comes to obtaining. The other issue, of course, we have a lot of these wash-wash cases, let me call them wash-wash, where the people who have been obtained from are foreigners. And so getting them to court to testify is almost impossible.
And what are you doing as a court to reduce that kind of a problem?
Now, what we do is we give the prosecution, much as we appreciate that the complainant also has a right to be heard under Article 50, but we cannot extend cases forever. And so we give the prosecution an opportunity to proceed with the case as far as is reasonably practicable. But remember, the accused is also entitled to an expeditious hearing. And so, of course, when it becomes untenable to go on mentioning cases because the witness is a Chinese, Turkey, whatever, then we offer the solution of getting the witness testify virtually, if it's not possible to avail him physically in court. So we have used that also, but more often than not, when they don't come, then I usually encourage the prosecution, instead of terminating the case, withdraw it under 87A. When you put your house in order, you can bring back the case.
Thank you.
So that is one thing we do. We have cases that are very clear. The moment you hear the first witness, the accused already knows he has no case. And so as much as possible, they try to really convolute the issues. This drags the cases because you find yourself making one ruling after another on whether whatever he's asking for is entitled to or not. What we have done when we do our mentions, we use the virtual platform as much as possible so that people don't have to come to court unnecessarily just for a mention. Now, once we confirm hearings, in criminal trials where there are many documents, we'd rather they come to court so that the sharing of the documents is easy. In civil cases, say confirmation of grants, applications, those ones we do virtually as much as possible. Where we have road traffic accident cases, where the witnesses are 2 or 3, we do them virtually so that we expedite the process.
I'm happy with that. Justice Majaj.
Good afternoon.
Good afternoon, Judge.
We were with you here in the commission for the last 5 years.
Yes.
So I'll just ask you one question.
Thank you.
I've looked at your sample writings, and there's one case that has intrigued me. It is Joseph Mbote Karwenji and Leonard Jao Mutura. Is a ruling on an injunction. What has intrigued me is that it is 29 pages long.
Yes.
29 pages, well written, cited authorities, gone through the arguments of all the parties. It is well written. My concern is, as a judge, would you have the luxury of writing 21 pages for every application for injunction?
Honorable Judge, even as a magistrate, I don't. But if you look at the introductory part of that ruling, I later came to learn that the advocate for the plaintiff was a newly admitted student. And so his pleadings were so convoluted that it was not possible. Like I said, he had mixed everything up. Why that ruling was long, in fact, I usually do 5 or 6 rulings and judgments every week. That one, I put just that one. Because I first of all had to organize the pleadings to ensure that the ends of justice are met. Because notwithstanding the fact that he was not able to succinctly and precisely express himself, he also deserved fairness. That one is particularly long because I first of all had to even rearrange his prayers. And thereafter, his affidavits were all mixed up. And that one particularly took me a very long. I just had that one ruling for that week.
Okay.
It's the only one. I think one and there is another. So occasionally I come across such where I really have to express myself in the judgment. But ordinarily my rulings are judgments, as you can see from the others, 10, maximum 12.
Okay.
Yes.
Secondly, just a more personal question. This is the second time you're coming here for interview of
Yes,
judgeship.
Commissioner.
The last time you did not get it.
No, I didn't.
What have you learned through that experience, and how would it affect you as a judge?
Thank you very much, Commissioner. The most important thing that I learned through that experience is that my own issues are personal to me. I am here to serve the people of Kenya. Serve them dispassionately, objectively, notwithstanding standing the challenges that I may have as a person. And so, after I did not get that, I went back to Kiambu and continued to serve with the same spirit of dedication, with the same spirit of service that I have always exhibited. That is number one. And number two, I came to learn that failure is a part of life. Life never promised anybody anything. All that you need to do is put your best foot forward and prepare yourself for any eventuality. I think the word is prepare yourself for any eventuality so that when whichever happens, you're able to take everything in your stride and move with the times and live to fight another day.
Thank you.
Thank you very much.
Yes, thank you. Thank you, your Honorable CJ. Your Honor,
Yes.
I'll not be long either.
Mhm.
You have served for long in the judiciary in various capacities.
Mhm.
I'm aware of your work. The record speaks for itself.
Thank you.
Now, you have served through a long time, even before the 2010 Constitution,
Yes.
and you have seen since the 2010 Constitution,
Mhm.
you have under the tenure of 3 CJs, 3 Honorable Chief Justices, and one is continuing.
Mhm.
You have been working under that the legal sector, but the judiciary.
Mhm.
Each of the Chief Justices launched their blueprints,
Mhm.
uh, and which were to guide their tenure,
Mhm.
to give their vision and missions,
Mhm.
and for which we were to the judiciary was to have it applied, implemented.
Mhm.
The current blueprint that we have is referred to as STAG, which you are aware of,
Mhm.
and which you have participated in.
Mhm.
Um, there are many principles. Two of them are the transparency and accountability.
Mhm.
So I would like you to tell us
Mhm.
how you understand or what you think the meaning, in your view, the meaning of those two words,
Mhm.
transparency and accountability, and their differences, if any.
Thank you very much.
Yeah.
In a way, they intertwined, but transparency is a situation where you are very open, number one. Number two, your systems are known and predictable. And number three, you are accessible as an institution. That is, when I say you, I mean as an institution,
yes.
we are. And number four, you engage people in decision making so that they are able to understand and appreciate why things are being done the way they are being done, because they participated in it, brought their ideas on the table, you shared what you think things ought to be,
Okay.
and then you came up with what you think would serve the best interests of justice in that region.
Accountability.
Accountability is, first of all, it takes me back to the realization that everything that I do as a public officer, as a judicial officer, is a trust that has been given to me by the owners of the Constitution, who are the people who I'm there to serve. They must therefore be able to understand why I am making decisions that are affecting their lives, their freedoms, and their responsibilities in a particular way. I must be available to serve them. So
you're talking about you as a judge.
Yes.
What about the institution itself?
The institution, of course, must be accountable to the people, number one. And in accountability, there's the access to justice under Article 47. That provision for access to justice means that, number one, we have to be physically available to be able to discharge our functions to the people as courts. Number two, the people must be able to understand the reasons why we are and why we do things the way we do, right? Number three, we have to be able to afford them an opportunity to access us at any given point in time, number one, by, like the Honorable Chief Justice has already done, zero-rated matters, court fees, so that the vulnerable, the children, are able to access the courts. Number four, whatever systems we put in place must be user-friendly. They must be able to access those systems in order to access us. So therefore, if we are going virtual, we are accountable to the users to be also able to use that system in a very simple way and access our services.
Thank you very much. And lastly, you have served the judiciary, you have cited many cases. Um, I don't see any election petitions that you did.
I actually haven't done any election petition
Yes.
cases.
Would you wish to do one?
I wouldn't mind. It's always a
You're a
good
senior
learning
officer.
ground.
I expected you to receive at least one or two.
I, for the past 10 years, the majority, from 2010 to 2020, I was sitting in this commission. And it's usually very difficult to juggle court work. And so
2022.
2010 to 2020.
What about 2022?
2022, I didn't get any.
Okay.
I wasn't given any.
Okay. Thank you. All the best.
Thank you very much, Honorable Judge.
Thank you, Chair. Good afternoon once again, Your Honor.
Good afternoon.
It is said a dead man commands nothing from his grave except what the living allow him to do. And the law of succession gives powers to the court to interfere with testamentary freedom of a deceased person. The Law of Succession Act was enacted in 1981. Post 2010, do you think we should still allow courts to interfere with wills?
Let me first of all confess that I haven't handled matters with wills, and so I'm not very conversant in that area, but generally, post 2010, perhaps, maybe.
Why? In terms of, especially on interpretation of the law.
Okay. Chair, with your permission, it has flown out of my head.
Okay, thank you. I see from your CV, you're also a member of the Tana Delta Commission of Inquiry into the ethnic violence in Tana North, Tana River, and Tana Delta districts. That's between 21st September 2021 and March 2013. In terms of access to justice, what would the role of the judiciary be in ending ethnic violence in the country?
I think in terms of access to justice, the judiciary should, as much as possible, make sure that there are courts. Of course, constitutionally, there have to be courts in every county, but they need to be available infrastructurally and accessible. I say this because what happened in Tana Delta, first and foremost, in that region, there's only one court, actually three. There was a court at Hola, there was the court at Lamu, and there is a court at, from Malindi, I forget the name of this place, actually, that's where we're sitting. Garsen, yes, thank you, Honorable Commissioner. Now, this is something that happens periodically. When there is drought in some parts and there rains in some parts, the pastoralists will automatically come down to look for pasture for their cattle. From our experience, most disputes were being settled by the elders because the distances were such that they were not able to access the courts because they are vast, the distances are very vast. And so it is the elders within the community that would sit to settle disputes when they arose. But then again, there was the issue of which elders, because there are basically two tribes that are fighting over resources. And it was therefore very difficult to build trust amongst the community. because of the fact that the tribes were just two. So it was very difficult even to get people to sit and settle the dispute. So they fought. So I think we need to devolve the courts as close to the people as possible.
Okay, thank you. All the best. Thank you, Chair.
Thank you.
Thank you, Honorable Chair. Good afternoon once more, Honorable Minde.
Good afternoon, Judge.
Right. Before we look at your performance as given to us by the Directorate of Performance Management, tell us about your work ethics.
Thank you very much. I am always punctual. If court starts at 9, it does. In the event that I'm busy in the office with some administrative work, I get there, I apologize to the parties and explain. Number 2, before I go to court, because to make sure that we move with speed, I always make a point of reading my files, either the day before or early in the morning, so that when I go to court, I'm able to competently guide the proceedings so that we avoid time wasting. The other thing that I don't do, I don't delay judgments as a matter of course. I deliver judgments weekly, like I said when I was answering Honorable Commissioner Majanja's question. How am I able to do that? On Tuesdays, I deliver my civil judgments. On Thursdays, I deliver criminal judgments and rulings. When I am sitting to decide when to deliver judgments, I usually have a good mix of light judgments and heavy judgments. And that's why I'm saying, like that one, it was too heavy, I gave it just itself for the week. In that way, I am able to not just meet the target of 20 per month, but I always surpass it.
All right. Thank you for that. And I think this report that we have actually agrees with what you've told us.
Thank you.
That between 1st of July 2023 and 31st of December 2023, you cleared 410 cases against the court productivity during the same period, which was 294 cases. Clearly, you surpassed the productivity of the court. And then in terms of the rate clearance in percentage form, you are able to do 19% out of the expected 14%.
Thank you. Thank you.
And the overall, your performance in comparison to average court performance is 136%. Again, that is very good and extremely commendable.
Thank you. Thank you very much.
Maybe just one area of concern is that when it comes to rate clearance, the percentage is 86% against the national figure of 104%. Why?
Thank you very much, Honorable Commissioners. Between July, 1st July 2023 to December.
Yes.
Now that's the period when the transfers were effective in the entire country. I think Kiambu, out of 6, we only remained 2. And so in the process of the other magistrates coming in, settling down, going to court, proceeding under Section 200, it took a toll on our case clearance rate.
Fair enough. Maybe another something that is a bit surprising is that when it comes to corruption prevalence for the year 2019, were you there?
I went there in October 2019.
Yeah. I'm seeing that the percentage here is 0.00 against the national level of 7.03. That's a bit surprising given the proximity of Kiambu and Nairobi, where I think all the conmen live. Again, I don't understand what the explanation could be for this.
Honorable Commissioner, thank you. I'm happy to hear that. It is true. Now, when I go to a court, I never do anything to change anything until I have observed how the court works. I look at the course lists, I see how the registries work, I study the staff that I'm working with, And in that way, I am able to learn the loopholes where the problems are. In all these years, I've learned that corruption thrives in a state of chaos, in a chaotic environment where nobody knows anything about anything. So once I've learned the environment, I also never work alone. I start with the magistrates. I invite them and we all share what we have observed. And then we brainstorm on what measures we ought to put in place. Once we have agreed, I then meet with the registry heads and section heads. I put to them what the problem is, and I also get to understand what their solution is. And then I meet the stakeholders, the bar. I do a lot of meetings, usually when I get to a station. And I usually tell my colleagues, you'll bear with me because we are one. I cannot make decisions for us.
So that strategy seems to have worked?
Yeah, then thereafter, you put systems in place. And what I've learned having put systems in place, I follow them with memos. So that when there's an infraction, an individual does not say that you are being unfair to them. You just produce the relevant memo and the infraction, and then we get things to work.
Thank you for that, and keep up the good work.
Thank you very much.
Right. Thank you.
Thank you very much, Honorable Chair, and welcome again, Your Honor.
Thank you.
I see a leader in you listening to you. I see a person who is very assertive.
Thank you very much.
And really, I also appreciate your wealth of experience.
Thank you.
Now, what keeps you motivated, and also how do you even motivate those who work under you?
Thank you very much. I believe that we make choices consciously. You don't make a choice by default. And once you make a conscious choice, then stick to it.
Mm-hmm.
I made a conscious decision to serve. And because of that, I do that which I promised to do. I also come from a background of very disciplined parents who are also persons who served in the public service with dedication and commitment. And so I picked it from them. But what motivates me particularly is the people that I serve. You know, the world is full of problems. We have a lot of indigent people out there. And when they come to you, they expect to get the best because we are actually the last bastion of dispute resolution. If you sit in a criminal court, for example, an accused person, when you're taking plea, you see was injured and everything. This is the safest place for them to tell you what happened to them because they believe someone will listen dispassionately and order that remedial measures be taken. And so when I think about people, and I imagine that I am sitting there and they implicitly trust me to do to them that which I undertook to do, I don't see why I should not do it. And that wakes me up every morning, makes me reach my court in good time, walk around, ask if the people have a problem, put systems in place to make sure they are served because they deserve it. They are the taxpayers, they pay my salary. If they were not there with disputes, I would not have anything to hear and determine. So they are the primary persons who are the reasons for my being. And that's, I got it into my system a long time ago. And it gives me that motivation. And I, in a society that's mired with all manner of things, I feel good when I'm walking around and saying hello and they greet me and say, we bless you, we are happy, thank you. Yes, and occasionally, because I'm in Kiambu, they will greet me in my mother tongue just to show me that they know me very well, that I may not be from there. So just service to the people, because I decided to do it consciously. I could have done many other things, but I chose to do that. So let me do it right and let me do it well. Thank you.
Thank you, Chair. I'm satisfied.
Thank you very much, Your Honor.
Thank you.
Now, if you were a judge, under what circumstances would you recuse yourself from a case?
Thank you, Honorable Commissioner.
And to whom would you ask for authority?
Recusal.
Yes.
The first thing is, if I feel that given the circumstances of the case, nobody needs to know, but I may not render a just and fair decision because of something that I hold dear to me, and it is the matter before me, I will recuse myself. Secondly, if, for example, one of the parties is a relative, because we are a society, I may be in Mombasa, my cousin is there, my uncle, my mother, my brother, my sister, I would state that in open court and say so and so is related to me in this manner, and so therefore it would not be proper for me to sit, even if I was going to be objective and dispassionate, I will recuse myself. Now, I have had a situation as a magistrate where I came to learn that my prosecutor had been compromised. And when I came to learn, I called my prosecutor and I called the persons who had compromised them. And I told them, this is the position. Here he is. I have no idea what you're talking about. I didn't receive any benefit to determine this case the way you want me to determine. And so you handle the matter with the prosecutor. I went to court. I put that on record and I recused myself. I would also recuse myself if someone is personally known to me. They may not be a relative, but perhaps we are affiliated in another manner that may not allow me to give an independent, objective, dispassionate decision. I will place it on record and recuse myself.
What if you are sitting in a bench?
I will need to disclose, like the Honorable Chief Justice has disclosed that we work together in Nakuru. And I know when we were sitting in the commission then, which is akin to a bench, we would disclose. And if we felt that we may not be able to render an objective decision, we would then recuse ourselves. So I'll disclose it to my colleagues in the bench. And if I feel that I am not able to render an objective decision, I will recuse myself. If they feel that given the circumstances that I have stated, it would not be proper for me to sit, because then justice may not be seen to be done. Even if it is done, then I will recuse myself.
Okay, thank you.
Thank you, Honorable Chair. Mheshimiwa, my question to you, what is an ideal team to work with, in your opinion?
An ideal team is a team with a common vision and a common purpose on how they intend to achieve that vision. An ideal team is a team that is participatory. It is a team where everybody feels they belong and where every idea counts, so that you carry everybody on board. And in crafting the vision for the team, every idea has been put on the table. They have been put together. You have come up with an even grander and better idea, and then you agree on what is easily achievable. What will you do to easily achieve those low-hanging fruits? what is not easily achievable, how do you propose to go about it, so that you make decisions together.
Okay. And what would you do if you were sent to a station and you don't find the team ideal for you?
Thank you. You build it.
How do you do it?
Thank you very much, Commissioner. Like I said, when I go into a station, I observe first. Having observed, we sit and discuss the challenges that are there. Then we agree on what we would want to do to handle the challenges and move forward as a team. So participation and getting the buy-in of every member of the team is important. Once you observe people, you will know who is strong in what and who is weak in what. Now, being strong or being weak does not mean anything. So you also know who can mentor who can be a peer to who. And you get people to work together so that we know which strengths of this individual we need to build on. We know which weaknesses so and so has and find a way of helping them and moving together as one.
Okay. Have you been in a position where, as a leader, you have had to allocate someone lesser duties because they're not pulling their weight and you do not want them to be a letdown?
Yes.
Please briefly tell us about it and why you felt that was the necessary action to take.
Let me just say, not lesser duties, but some duties. Now, plea taking in criminal courts is a very, let me say, very important exercise for any court. And if you want to stem corruption, then you must find a way of ensuring the integrity of plea taking. Personally, I am not the kind of person who keeps the pleas and then in the morning I decide so and so you're taking. I do a timetable. I do a duty roster, but before I do it, we sit with colleagues and I tell him that is the oath that we all took and I expect that we all apply it. And so I will not deny anybody work, for starters. So I allocate duties appropriately. But then you must monitor from the court user stakeholders. When you realize there's a problem, like when I do, I don't deny them work as such, but I space them out so that if we are 7 magistrates, then I know who I can give 2-week break, 2-week break, 2-week break. But I know who I will give a 7-week break so that as we are trying to win the court of corruption, and I know where the weaknesses are, I don't give them as much opportunity, if you're getting my point. So I
Eventually, Yona, what do you do with these people? Because you cannot keep, for lack of a better word, denying them that opportunity because they're not doing what they're supposed to do. What do you end up doing with them eventually to bring them up to speed with the rest?
One thing about me, if there is a problem, I'll sit with you. I'll call you. We'll have a closed door sitting, and I will tell it to you as it is. And because most of them are my juniors, I usually tell them, you know, either you're my little sister or little brother. It would be very wrong for me to know that there's this and that going on about this, and I don't let you know. And I tell them, and sometimes they agree, they promise to do better, sometimes they deny. I've even had situations where complaints have been sent to this commission, and I'm still saddled with the officer. So in situations like that, it's very difficult then to even try to talk them out of the problem. And that's when I have to find other means of just getting work out of this officer's hands, because their matter is here. I am the one who forwards the letters. They do their responses. I forward them. Nothing much happens. So I have to deal with it. So when I reach that situation, then I do those strategies. But ordinarily, if there's a problem with a colleague, I'll call you and I will tell you. Sometimes I get it from the bar bench. I get it from members of the public who come. And I tell you, this is it. What do you say? What do you think? And then I just cancel them.
Okay, thank you.
Thank you very much.
Thank you very much. We always call you Commissioner Ominde.
Thank you.
Always a commissioner. What is your area of strength in law?
Criminal law.
Criminal law.
I've done it for a very long time.
Okay. Very well. Thank you very much. I think it's been a very engaging session between you and the commissioners. We have even gone over the time that we normally do. But thank you so much, for the years you have given to the judiciary, contributing immensely for the 33 years, even in terms of other developments in KMJA, the training of judges and magistrates, and also in this commission. That shows that you are a firm leader who is quite seasoned. I realized from your documents and even recommended you for a UN appointment of a judge. Not a Kenyan one, but a UN one. So on behalf of the commission, we wish you well and thank you for the good work that you are doing for the institution. I think this brings us to the end of the interview, unless you have a question for us.
Thank you, Honorable Chief Justice. Thank you, Honorable Commissioners. I do not have a question. But having sat in this commission for all these years, I know what it means in superintending over an institution. And so therefore, I just wish you well. Pray for you. Wish you God's blessings in everything that you do. But otherwise, on my part, I'm really, truly grateful and I appreciate the opportunity you have given me. I thank you very much and I wish you well.
Thank you. We wish you well. We'll get in touch with you when we complete the exercise.
Thank you.
And we send you with our greetings to the people of Kiambu.
Thank you very much.
Have a nice afternoon.
Thank you, Honorable Commissioners.